compliance from the system office. Have you had the opportunity to take a look at his information that I sent out when I did the invitation? You should have a handout in front of you. There will be another session that we'll schedule later on that will continue on with this process. For those of you, are there any hearing board people? Okay, this is kind of the preempt to Thursday's training. So it'll give you a little bit of information before you get into that on Thursday, so this is a really great place for you to be today. There's 2 sign-in sheets floating around. Please sign both of them. One of them is for the Title IX reporting. The other one is for you to get credit with training and development. So be sure and sign both of those sheets. And with that, we'll turn it over to Rick.
Good afternoon.
Good afternoon.
Good afternoon.
But we'll do what we can to make this as entertaining as possible. Do encourage you if you need to get up. I'll take a couple of short breaks during the course of the afternoon. If you need to get up and move around, certainly won't be offended. If you need to, there's some beverages over there, as well as some snacks that are graciously provided. I got in my car this morning at about 4 a.m. My wife and I were judging whether I should drive up to the Dallas area last night, stay over, and then drive in. And I have this thing about sleeping in my own bed, which usually serves me well, so I decided to stay home last night and just drive the whole thing this morning. But I'm waiting for that second one to kick in, but we'll all get there. So I did want to walk through how many board members again? Show my hand. Dexter, thank you. And then is everybody else on the stakeholder group, line group? Okay. So that's, and so I'll talk a little bit about that in terms of mixing populations today. There are kind of 5 steps to this, and so we'll do some brief introductions around. And then the stuff that you see in blue today will cover determining violations and an overview of Title IX. The overview of Title IX will span both sessions that will end today with it, and then we'll pick it up again at the next session. Then we generally will dip into a case study, looking at a fact pattern related to a sexual assault case, and then talking about sanctioning student misconduct. And that's all sanctioning, not just Title IX cases that I would typically look at. Just ask you to be engaged, participate, and ask questions. Lean into any discomfort that you might have. This is a good place to do that. No one's lives are at stake. We're not actually looking at anybody's actual fact pattern. We have an opportunity to do this in a little bit of a cocoon, if you will, in a protected space. And so I would ask that, we're going to be covering some fairly sensitive material. There may be some colorful language as we go, given some of the subject matter or some of the examples I might share. I would ask if you disclose anything, please maintain privacy with each other. But as far as anything I say in here, well, that's fair game. So feel free to use it as you see fit. Because of the timing of this, we're going to have about 6 hours together over 2 sessions. And of course, predictably, I'm trying to cram about 8 hours of material, go figure. And so sometimes I'll have to shorten up some Q&A time that I would otherwise like to explore. I can't go down quite as many rabbit holes as I might like to. And so if I need to abridge something, I will ask you to kind of maintain a little parking lot list for yourself, so that if there's areas that you want to make sure that we talk about, write them down, and then let's make sure that by the time we're done together, we've had an opportunity to knock off all those lists, okay? So I'll ask you to keep your own list. Of course, if I'm giving a presentation and I'm coming out of the General Counsel's office, I'm going to need some disclaimers. And so first, this is reflective of my experiences and opinions. I may work for the General Counsel's office, but I am not here as an attorney. And do not have a law degree, so I am unfettered by that for the purpose of having these conversations. The material is intended for a wide audience that assumes no knowledge. And so in some cases, a lot of this may be brand new to you. In other cases, it may be almost entirely reviewed. We're going to try to hit everybody's needs. But because we're mixing two different groups, I think you're also going to get a little bit of a different exploration of somebody else's world to kind of just see what other people are having to contend with, particularly if you're not on the case management side of doing actual hearings. I hope some of this will be enlightening in terms of how complicated it is to hear these cases and how much goes into it. This really is quite an art. And then I'm very intentional about giving you the text and working off of the text up here, in part to try to accommodate learning styles and understanding. Some people like to see it, some people like to hear it. I also want you to walk away with it so that you don't have to spend your time today taking a lot of notes. Write down what's important to you, but otherwise I want to free you from needing to write a whole lot down. So what I'd like to start with is if we can go around and just give your name, preferred name, what you do here, where you're from, how long you've either been with panel or Title IX, and then what you'd like to take away from this training. And if I could have somebody brave enough to start. Thank you.
I'll let Dr. Romero go.
Oh, okay. And then
I'll be happy to do that.
and then I will ask, just for brevity's sake, if we can go in a row from where we start.
So my name is Edward Romero, and I am the Chief Diversity Officer here on campus. And I'm originally from New Mexico, and I've been in some way affiliated with Title IX for about 5 years. And I'd like to take away from the training just more knowledge and information.
My name is Maggie Salem. I work in the School of Ag. I live in Emory, Texas, from Nebraska. I'm brand new here to this situation, and so anything you give me today,
Okay.
that's what I want to
Fair
learn.
enough.
Anything you have to offer.
Nice low bar, I like that.
Easy to please.
My name is Bethany Farrell, and I work in career development. I am originally from Dallas, but I lived in South Carolina for 12 years for college, and I moved back about 3 years ago to work here. And I'm just now joining the committee, and so I am in the same boat as Maggie. It is all, if you told me lots of lies, I'd be like, oh, okay.
Cool.
I probably believe it.
I'll get that version of PowerPoint out.
Okay, great.
My name is Kishore Gurudaya. I'm professor of economics in I came to this university about 7 years ago. I taught for 6 years in Louisiana, Lake Charles, Louisiana. And there was a hurricane and all those things. My house was blown. I got a little tired of running away every year for hurricanes, so I said, okay.
Time to go.
And I love Texas because I did my PhD a long time ago, during the time of dinosaurs. From SMU 30 years ago. So I love this area. When I joined this group here in the committee, I am in about a dozen committees, and I found that I am in this committee too.
You must have missed a meeting, huh?
My name is Amy Fonseca, and I am the admin for the Police Department. And I'm actually from the Dallas area, and ended up here because I went to school here. And I'm new to the community as well, so we can work around.
Thanks.
My name is Kristen Lewis. I work for enrollment management. I'm the admin for the USO. I have been in some capacity, either student or employment, or student worker with the university for the last 10 years. I'm from Commerce, so been here for a long time. So this is I'm new to the panel as well, so I just want to learn as much as I can.
Thanks.
Deirdre Hill, McNair Scholars Trio, originally from Alabama, rural Tyrol. New to the panel and just need to be informed.
Okay, thanks.
Dennis Mosley, graduate assistant for the Office of Judicial Affairs. I'm originally from Lafayette, Louisiana. I'm new to the family as well, so any knowledge will be great.
Hi, I'm DP Shady, Associate Director of Student Activities and Special Events here at the Urban Student Center. Been here for about 6 years, but I'm originally from the Raleigh, North Carolina area. I've been a part of the hearing board for about a year and the Title IX committee for a couple of years now. And just, again, like everyone else, I'd like to get more information to be able to better educate the students that we're with.
So you're overlap, you're doing both. You're doing both then? Yeah.
Hi there, I'm Donna Spinato, and my position with AM Commerce is I'm chief of police. I'm also on the committee, and I've been on it, I think, 5, 6 years. Whenever it got started. I'm one of the dinosaurs from here. I'm actually from Commerce, left Commerce, came back because I left the institution. And what I really want to most take away from it is best practices.
Hi, I'm Rebecca Turk. I'm the Director of Student Disability Resources and Services. I am also from Commerce and recently back here for 95 years. How long have I served? I've been on Commerce since started 3 or 4 years ago. Investigator trained, on the hearing board, all of the above, always seems that way. And I would just like to take away anything new I can learn or understand about this meeting.
You've done all the TICSA training. Thanks.
My name is Junior Sanchez. I'm the coordinator of Training Outreach and Retention. I might possibly be on the hearing board next year. So I want to know what I'm getting myself into.
Fair enough.
If I do get into it. So I've been here for 9 years now. I grew up in the area. So I guess I could be considered a dinosaur. You make it past it. I don't know. I've been here for 9 years. I don't have much.
Thanks.
My name is Sarah Northam, and I am the head of research and instruction at the library, which is a fancy way of saying I'm a librarian. I grew up between Ardmore, Oklahoma and Paris, Texas, so I could insult both states equally. I, once upon a time, came here for school, never left, and it kind of sinks you in and you just stay. I think I've also been on the committee since it started, if I'm not mistaken, I think. And I just want to know more about Title IX. You know, it's like I know enough to get me in trouble, so I need to know enough to
Unfortunately for the system, that applies to me. So.
act like I know something about it, I guess. I don't know.
Hello again. We met.
Yes.
Yes. I am Tomas Aguirre. I'm the Dean of Students and Assistant Vice President of Student
That long title.
Or Campus Life and Student Development. I'm from down in the West Texas town of El Paso, where I fell in love with a German-American girl. So, you know the song. Title IX, probably almost 20 years, more than I care to admit. And yeah, we met at the systems meeting and wanted to see a continuation of the presentation we gave there. So, glad you got it.
Singing Village of Walton.
Joshua Moore, I'm the Associate Director for the Federal Engagement Powers and the Virtual Office, also known as SEEDS for short. I am from the Bluegrass State. Just moved here a little over a year ago. I've been on the hearing board since January, and I have somehow signed myself up for Title IX Investigator training, so that's partially why I'm here. And I guess what I'll most like to take away from this training is just some more information and knowledge that helps me along the way. Thanks.
Hello everyone, my name is Danielle Davis and I'm the director for the long title there, and then there's also another long title for lead as well. I would like to say the present. So I'm actually, I Nebraska. I'm one of two people that's not from the South, and I'm okay with that. I am originally from Illinois, and the suburbs, so Hazelhurst is where I grew up in that area. And I went to the University of Illinois Champaign, Iowa. So, I have been on the hearing board panel since I think its inception a couple of years ago. And then I had the privilege of going to the inaugural ASCA, social assault training a couple years ago as well. So I think for me, it's one, a little bit of refresher, but to figure out some of the also ins and outs, things that I don't know, and just becoming more abreast to that.
Well, good afternoon. My name is Kyle Williams. You can call me Kyle. I am the area coordinator here at Texas A&M University of Commerce for the Department of Residential Living and Learning. I'm probably the other person that's not from the South. I am from the Buckeye State, OH, right. I moved here from the Northeast, so I did all my schooling and everything in the Northeast, so I moved here from the Philly and New York area. This is my first year on the board. I've been involved with student conduct for the past 5 years, and my previous institution did deal with Title IX, so just looking to get updates and everything coming back into the specific Title IX or the University.
Brian Vaughn, Assistant Chief of Police here at the university. I'm from Sulphur Springs, Texas. I'm not on the panel or the Title IX committee, but in law enforcement, we are constantly trying to marry Title IX and the law enforcement aspect together, so I'm just here to learn more about that.
And several of your colleagues this morning.
Use a tardy one. I'm Craig Case. I'm the women's volleyball coach. I'm from Minnesota. I'm added to the list of Northerners. And my parents, I'm worn out because my parents just came down for the weekend and then they drove home yesterday. I just started serving on the hearing committee, and I'm pretty wide open. There's a lot of things I'm interested in as it relates to Title IX, so that's what I'd like to take away from it.
I'm Robert Wolf. I'm doc student in the higher ed leadership department. I'm GAR and GAT for the ed leadership department. I was born in Ladonia, but I'm from Mesquite, and I live here in Commerce. I just got on the panel this semester, and I want to be able to learn everything that is offered.
Sounds good. Thank you all very much. And Michelle, sorry you're going to have to like hear things twice while you're here. As I was explaining to the group this morning, when I first came into the Texas A&M system in February, I sat down with Dave Parrott, who some of you might know as the Associate Vice President for Student Affairs while he was at Texas A&M. He's now over at the University of Florida. And since he and I have both kind of floated all over the country, he gave me some good advice, just having relocated to Texas, which is I'm supposed to come into any room that I enter and say, hi y'all, I'm not from here, but I got here as fast as I could. But I also want to do that and give him an appropriate citation so that nobody can say I plagiarized. So I am also a Northerner, from Albany, New York, and so grew up in the Capital District up there, went to school up there, and then did graduate work for 2 degrees in Illinois. And so I spent most of my time, actually I did a 25-year career in student conduct. So I'm coming from the dark side to an even darker side. Is kind of the way I look at it. It's been, I did some time at Georgetown, working in student conduct there. And student conduct, my experience has been is that I do the student conduct side, but it's a broader range of conflict resolution methods, and so I've been doing mediation and other forms of restorative justice and other forms of dispute resolution for a long time. But got into Title IX, and I'll walk through some of the national history that we're going to get into today, kind of parallels my own career path. And then about 11 years ago, I became an associate in the students at Illinois State, which meant that I got all the fun areas such as fraternity and sorority life and legal services and student conduct and orientation and a bunch of other areas reporting to me. So the supervision of conduct stayed there, and I served as the Title IX hearing officer for many, many years, going well back before we called it Title IX work. And so very similar history in terms of how long we've been doing this work. I've also done a lot of work with the Association for Student Conduct, and you were talking about ASCA, that I'm a past president of that organization and now work primarily with the TICSA, the Association for Title IX Administrators, and with NCR, the National Center for Higher Education Risk Management. And so this job was particularly appealing to me to come here because I knew I wanted to work specifically in Title IX administration, and what a great opportunity to come work with an entire system of campuses as opposed to being just bound to one campus. And so that's been a lot of fun to kind of make this circumnavigation around the state of Texas and just learn all the different cultures and all the different environments. And so actually I'm headed over to the only other campus that I haven't been to, which is Texarkana, tomorrow, to do a little bit of work with them, and then we'll be doing a lot of training and consulting with each member campus as the job continues to kind of evolve. We've also added some investigators, which some of you will be finding more out about, so we'll actually be able to dispatch some investigators from our office to be able to assist campuses that are doing some high-level work. These are the areas that we're going to get into before we look at Title IX specific. So we're dealing specifically with some hearing board applications and skills, but I think it's going to be really helpful if you're just coming from a Title IX committee perspective to kind of understand how this work works. It offers a very different perspective. So we're going to take a look at burdens of proof, what burdens exist, where they're used, why we use the burden that we do. We're going to take a look at how do we weigh information, what are the factors we're looking for when we weigh information, and what types of information exist that we would be weighing. And then I'm going to give you an opportunity to practically apply that so that you can see what the preponderance tests look like given some of the fact patterns that we may experience. So I'm going to do that in kind of a non-Title IX context just to kind of warm you up to the activity. So there are a number of terms to describe burdens of proof, and these are the 5 general ones that we see. We have beyond a reasonable doubt, clear and convincing, preponderance of the evidence or information, substantial information which is proximate to probable cause, and then reasonable suspicion. So these are the burdens that we know of from society. How do we define these and where are they utilized? Let's start with beyond a reasonable doubt. Could somebody give me a definition of beyond a reasonable doubt?
There is enough evidence or truth in statements that you have no doubt that that person committed it or participated in it.
Good. So you have no doubt and that it's been tried and tested, it's been subject to review, it's been subject to questioning, and that any other potential explanations simply pale in comparison based on the evidence that's available. Okay? So there is literally no other explanation other than the one that you arrived at. So beyond a reasonable doubt, that sounds like a very high level of burden. And if you think about this statistically, so we did a verbal definition, but a statistical definition is somewhere between 90 and 99% certainty. Now some people prefer the wordy version, some people prefer the numerical, whatever works for you, but we are talking about an extreme degree of certainty. Where do we use this? Court of law. We use it in criminal law. And specifically criminal court as opposed to civil court. And so why are we reserving the beyond a reasonable doubt standard to the criminal court process?
Because there's punishment involved, and we have to make sure that when we hand out punishment that we're absolutely sure we're doing the right thing.
Yes, I'm going to take what you said and go just a little bit further with it. It's punishment that affects someone's life, liberty, or property interests. So what is guaranteed to you in the United States Constitution? And so we know that if we're going to deprive someone of life, liberty, or substantial property, that we are going to do so with due process of law and the highest possible burden. The value statement that was made by our founders was that it was better to let a guilty person walk free than it was to deprive an innocent person of life, liberty, or property. That was a values decision by our founders. You can argue whether or not it was the best call, whether or not it's the best burden. But we have said for life, liberty, and property, this is a standard that's going to be applied. Not all property money, substantial property interest. So that's where we use it. We use it in the criminal courts. How about clear and convincing? Can anybody give me a good definition of that? This one's a little harder. Anybody have people heard of this standard? Clear and convincing? So the best definition I have ever heard of clear and convincing, I kid you not, is it clear and is it convincing? That's it. Where is this, oh, and if you want to look at it statistically, somewhere around 67 to 75%, 2/3 to 3/4 sense of certainty. Where do people use this? Any idea?
It's civil, isn't it?
Sort of. A certain kind of civil. Family. And only particular family cases. So it's going to be family cases where they believe that a preponderance standard is not enough. Typically that's going to be held out for custody, visitation issues, so family matters. You will see that some courts will utilize a clear and convincing standard. You will also still find some colleges and universities applying that standard for student conduct, although Title IX has kind of decapitated some of that by demanding a preponderance standard for Title IX cases. Some institutions are pretty flaky, like if you look at the University of North Carolina at Chapel Hill, they have, and oh, you're going to love this, for their Title IX cases, they use preponderance of the information. For every other student conduct case, they use beyond a reasonable doubt. That's an interesting process. And that's also a process where you get to have attorneys represent you in the student conduct process. So, you know, every state will have its nuance. It's not as though we won't. But clear and convincing, you're going to find a very small sliver of cases in the civil courts that will be using that standard. Preponderance of the, oh, go ahead.
Clear and convincing, I have a problem. It's subjective, because something clear to you may not be clear.
Of course.
Something convincing to you may not be convincing.
And honestly, that's true of all burdens. Because beyond a reasonable doubt, what's reasonable mean? Right? So that's actually true of every burden. But I think clear and convincing, the thing that people struggle with is that when they go for clear and convincing, where they actually end up tends to be a preponderance or beyond a reasonable doubt. It's very hard to stay in the middle. At least that's been my experience in seeing people utilize that. Preponderance of the evidence or information, what's that mean?
Isn't it like, is the statistical, isn't it 50%, like we look at 150%?
More than 50, yep. So 51 or 50.1. How would you describe it verbally?
Overwhelming evidence.
And actually, overwhelming would probably get you up to clear and convincing or beyond a reasonable doubt.
I would say, given the information that you have, it's more than likely that you were involved.
More likely than not is the standard descriptor that we use there. It is more likely than not. And it's not that there aren't potential other explanations. It's that this explanation is the most likely. Now the catch is, it's the most likely based on the information actually in evidence. Here's what panels will tend to do a little bit, and one of the things I would try to train them not to do, is to submit facts that are not in evidence. And so that's something, and I'll talk a lot more about that as we go, but when panels begin making up alternative scenarios about facts that are not actually on the table, that becomes highly problematic. So that skews the standard that we're using because people start guessing about things that are unknown. And so I'll talk to you a little bit about that. I won't be going through questioning and listening exercise today, but I'm going to, I think, at least demonstrate the value of why you need to question so well.
Is that kind of similar to where, like, I sat on a jury once, and they could only talk about situations pertaining to the current case. But when we got to the sentencing, then they could pull in evidence or stuff from previous cases.
Yeah.
So is this kind of that same thing?
It is. It's unrelated to what we're talking here. Right. But yeah, we'll do the same process, that their history is off the table unless in Title IX cases it demonstrates a pattern of behavior. Patterns of behavior do become important as we're looking at a finding. In most student conduct matters, you're going to first have a finding based on the facts, then move forward with sanctioning. The important thing, and this is why, and we're going to talk about comfort with preponderance in a few minutes, I think a lot of people are really uncomfortable using a preponderance standard. Part of that is because we're thinking ahead to the outcome as opposed to focusing on what's right in front of us, which is whether or not there's a violation. And if I start sitting there thinking, well, do I have a preponderance? Well, if I do, that means I got to throw them out of school. Wrong. I'm having the wrong conversation. The conversation I need to be having is, did they violate the regulation? Once I've done that, then I go on to have the sanctioning conversation. The sanctioning conversation is we'll see next time around when we do the second part of it, and we walk through a sanctioning exercise. You have a great deal of latitude on sanctioning. Stop worrying about the sanctioning before you get there. And it's one of those things. So with preponderance, we're going to talk about the comfort of it in a minute, because I do want to walk through that. How about substantial information or probable cause? And these are essentially the same standards. One we use in student conduct, one they use in police work. So from police work perspective, what's probable cause mean to you?
Everybody
I got two cups in the room.
I put a big pretzel in my mouth. I'm sorry, you want to talk about it?
Probable cause to me is the facts that you have lead you to believe that this happened.
Right. So, and do you have sufficient cause to effect an arrest, right? And so you don't even have to meet the preponderance burden, do you? You just have to have a pretty heightened suspicion and some evidence, and then you have probable cause for an arrest. And on the student conduct side, we would refer to that as substantial information to determine whether or not we had cause to even bring a complaint. Okay, so if I can't meet that burden to even get to a preponderance, why am I wasting time of the people that would be involved in the process? And so this tends to be somewhere in the 40 to 50% range. I'm not too worried about numerics here, but it's less than preponderance. And then finally, we have reasonable suspicion. And in that case, I will turn specifically to the officers we got in the room and tell me what reasonable suspicion means to you.
Well, in every situation that we go to, there's some type of reasonable suspicion based on the facts and the totality of the circumstances that you're seeing when you're out there observing where you're at.
So if we put this into a context that I'm driving my car on the highway, and maybe I'm trying to like eat my lunch, get that the audio CD in there, and I'm swerving around a little bit, and I'm giving you just enough suspicion to pull me over, right? So what's the thought process that you now go through as you're coming up to the car? Are you looking for other things? Okay, absolutely. And so the way to look for other things is you're looking at physical evidence that's in plain view. You're engaging me in a conversation about, so where are you coming from? Where are you headed to, right? And this is really it's a conversational technique, it's sort of an interviewing technique that we're using to try to see if there's anything here. Or is this just person's acting like an idiot on the road and they're not paying attention to what they ought to be doing, right? So this is reasonable suspicion. Reasonable suspicion, though, only applies to whom? Who's the only people that get to play with that standard? That's law enforcement. Because it's not the reasonable suspicion of any person, it's the reasonable suspicion of a law enforcement officer and the performance of their duties. Okay, so it's the cause to pull over, the cause to detain. Now, as a citizen, what can I do when I'm having that conversation? If I know that technique, what can I say to the officer? Officer, are you going to write me a ticket, or are you going to issue me a warning, or am I free to go? Right? If I know that that's going to happen, and that's a shortened form of that conversation. Okay? But reasonable suspicion only applies to police. It's a very low bar. Because it's only really, if I think about it in a legal context, it's sort of a little bit of a legal fishing expedition, but it's one that has a basis. Okay? And that's fair. So these are the burdens that exist within society. Why do we use a preponderance in our cases? Well, the first reason we use a preponderance, and actually let me go back and do a little history lesson as we get started. Is anybody familiar with, prior to the early 1960s, what the name was of the legal relationship between the institution and its students? And loco parentis, in place of the parents. That meant when you got dropped off at the door as a student, the institution retained the legal right to discipline you in whatever way it saw fit. And then we had a little thing in 1961 called Dixon versus Alabama. We had students, African-American students, at a lunch sit-in at awards from Alabama State who were summarily tossed out of Alabama State without due process. Well, of course, due process wasn't a thing. So the case went to federal court. And the court said, oh no, due process is a thing. Because you were depriving people of a property interest. And therefore, if you're going to deprive them of a property interest, you will provide them due process. How is due process defined? Due process is literally defined as the process that is due. Yeah, I'm not kidding. Because the definition changes based on the burden you have to meet. So due process in the criminal lens is dramatically different than due process in our lens. And if you don't believe me and think, this is just a guy who wants job security, okay? And trust me, the behavior of students over the past 26 years, I've had job security. First, we use a preponderance test because it's reflective of the educational nature of our institution. Now, it's not just the quote I'm going to give you, it's the source of the quote. School regulations are not to be measured by the standards which prevail for criminal law and for criminal procedure. Harry Blackman, 1967. I think we understood due process in the 60s as it began to emerge out of the Dixon case. By the 70s, there was nuance, and there was certainly regional nuance based on whatever circuit you were in. But ultimately, we knew by the 70s how to handle students who were accused of violating regulations. This is actually a pretty settled area of law, so a lot of times I have to scoff at some of the public debate that I hear that is really uninformed about, well, you all don't know how to provide due process. Actually, we're pretty brilliant at it. You know what we suck at? Anybody know? Providing equity. We've kind of sucked at providing equity. And so what we're finally getting on board with, thanks to a little bit of regulatory overreach from our friends at the Office for Civil Rights, is finally figuring out that we need to be more concerned, or as concerned with equity than we are with due process. And recognizing that the due process, in fact, applies to both parties in the process. That's what we've had to catch up on. And thus, I'll get into some of the DCL stuff later, the Dear Colleague letter, but I love the next two quotes. The discipline of students in the educational community is, in all of the cases of irrevocable expulsion, a part of the teaching process. Actually, Justice Blackman, I disagree, and I realize this was written in the 60s. I think expulsion's part of the teaching process too. I tend to look at it that way. In the case of irrevocable expulsion, the process is not punitive or deterrent in criminal law sense, but is rather the determination that the student is unqualified to continue as a member of the educational community. Even then, the disciplinary process is not equivalent to the criminal process of federal and state criminal law. For while the expelled student may suffer damaging effects, sometimes irreparable, they note that, he or she may not be imprisoned, fined, disenfranchised, or subjected to probationary supervision. The attempted analogy of student discipline to criminal proceedings against adults and juveniles is not sound. That's just a mouthful, and it's quite profound. So what we have here is a system that is unlike the criminal process, and it's the courts that have told us that we shouldn't look anything like the criminal process. And so by judicial mandate, to impose upon the academic community and student discipline the intricate, time-consuming, sophisticated procedures, rules, and safeguards of criminal law would frustrate the teaching process and render the institutional control impotent. So we have aims that are unrelated to what takes place in criminal law. There's a property interest still at stake, right? But I'm noting the difference between a property interest and a substantial property interest. What court was it that said anyone has a right to a higher education? No court. Not in this country. And even if a court did say that, they will never say that a student has a right to a degree from Texas A&M University Commerce. They don't have that authority. And so this is a privilege to be at any institution of higher education in the United States. That's a privilege that can be lost. Does that do harm? Absolutely, it could potentially do harm to you. And that's why we provide the process that is due. And that's it. It's not going to look like the criminal process. It shouldn't look like the criminal process. The other reason we use this burden is because OCR says we will. That's my shorthand. Because what OCR says, and if you're not familiar, I'm going to use DOA, Department of Education, DOJ, Department of Justice, and OCR, Office for Civil Rights, and they have one in Ed, and they have one in Justice, and they have one in a bunch of other federal agencies. So OCRs are kind of everywhere. But in this case, what DOE OCR has said is, look, when we do our civil rights investigation, guess what burden we use? Preponderance. By definition, guess what burden you will use? This is a civil matter. And so we're going to use the civil standard. That doesn't yet carry weight of law. I would not, however, encourage you to be the institution to buck against that trend. Okay? That usually calls for a rather lengthy and ugly visit. Ultimately, I think it'll be codified at some point. They took a pass on it when they were doing VAWA amendments, and basically what I heard in that from somebody who was who was one of the participants was they just kind of lacked courage to have that conversation, and I think the department will have a lot of lobbying interests against that. Particularly if you're familiar with the Foundation for Individual Rights and Education, FIRE. FIRE and some other free speech groups are really opposing this entire effort by DOE. And so there's a bit of a political bloodbath going on with respect to all this. Texas has obviously been caught up in it now as a result of the transgender issue. We'll talk a little bit about that as we go. But essentially, what we've got here is for sexual harassment, sexual violence, sexual exploitation, relationship violence, and stalking, we will use a preponderance test. So it stands to reason if we're going to use them in the most serious cases we're ever going to see, because the only thing I can imagine worse is probably a murder case, When's the last time you had a murder case in your student conduct process? It's not gonna happen, is it? Not gonna hear a capital crime. It's just not gonna make its way into your process. You might remove a student who's accused of murder, but you're gonna find other ways to probably do that, or use reports to find means for dispensing interim measures. But ultimately, you're not going to be doing a capital murder case in the process. So I cannot fathom more serious, more affecting cases to people than Title IX cases coming through the process. All right, so if we can use that preponderance burden for Title IX cases, why wouldn't we use it for an alcohol violation and a drug violation? Right? And that's the basic philosophy behind this. So next, is it possible, and this is where people get caught, is it possible that we can make a mistake while employing a preponderance test? You don't have to raise your hand, but feel free to. Is anybody here just really queasy at the idea of making decisions about people's lives using a preponderance test? Okay? That's understandable. I've got a different solution for it than most people are going to think of. So we'll walk through what that solution looks like, but it's completely understandable that you're going to be queasy with what is perceived to be a lower standard. Well, and it is a lower standard. There's a lot of talk in the higher ed, actually in the media, about the fact that we've reduced our standard from beyond a reasonable doubt to preponderance of evidence. Is that true? Number one. It's not. It's not even close to true. Where did it come from? Not so much court cases, but the fact that Princeton, Yale, Harvard, North Carolina, Duke, and some other schools that are prestigious institutions have in fact been using a beyond a reasonable doubt standard. Well, I don't know about anybody else, and forgive me if you have an education from any of these wonderful institutions, but when I look at best practice, I have never gone and looked at Princeton, Harvard, Yale, and all these other schools. In student conduct work, in student affairs work, in Title IX work, they're not where they need to be. And so we look at mid-majors, we tend to look at public schools, because we're typically going to find our best practices there. Okay? So is it possible, let me ask you this, if we're going to make a mistake when employing a preponderance test, is it at all possible? You all can make a mistake on a decision, right? Absolutely. Does the criminal justice process ever make a mistake using beyond a reasonable doubt? Yeah, they do. I come from Illinois. They shut down the death penalty because they were finding too many cases of inmates on death row that were ultimately cleared. People make mistakes. Sometimes those mistakes are errors, and sometimes those mistakes are intentional. They're not mistakes. So we recognize that the criminal justice system makes mistakes. Why does any system make mistakes? Because it's comprised of human beings. And we are flawed by our nature, and so any human decision-making involves the possibility of making mistakes. So step one of this concern about making a mistake is let it go. I won't stand up here and sing a Disney song, so you can all thank me for that later.
Oh, come on.
Please let this one go. Yes, you could make a mistake, and you could get hit by a bus, so maybe you shouldn't leave your house. Okay, but you know how to avoid getting hit by the bus, right? Generally, look both ways, right? I mean, simple stuff. So let's talk about what we might do to avoid making a bad decision. The goal here is to make the best possible decision based on the best available information that exists in evidence. And then we do our job. And the better we do our job, the less chance that we're ever going to make a mistake on a decision. So if I imagine this is a canvas, a blank canvas, and I've got an incident involving people's lives that I'm going to have to pass some judgment on, and this starts off as a blank canvas. And as information comes in, we fill this canvas, don't we? We start to create a picture. And so when you have an investigator that's going to go out in a Title IX case and collect a great deal of information about the case that you're going to review. And, you know, as I was talking to Michelle about, sometimes they're going to come back with like 95% of this filled in for you. It's going to be brilliant. You're not going to have to do a whole lot of work to try to extract information. In other cases, maybe they couldn't get some information. Maybe they just overlooked some things. So you're talking about maybe getting 80% of this portrait filled in for you. Your job isn't to make the decision based on the 80%, but to try to collect as much more information as you possibly can. And then, rather than go into deliberations, and this is something I always like to guide boards on, rather than go into deliberations in the first part of the conversation be, so do they violate policy? Wrong place to start. The right place to start is, so what happened that day? Or what happened that night? And start to put together a chronological view of what took place. Let's lay out a sequence of events. If you can all agree on a board to what that sequence of events looks like, the violations will speak for themselves, whether or not there's any policy violations. It will fall right out of that story for you. But what I need you to do, as panel members, particularly here, is ask questions that will get the rest of that information out to you. And then only use the information that's in evidence. And this is key. So I have one person's story, and I have another person's story. Those are the only, if those are the only things I have, those are the only things I can consider. I cannot go, well, you know, I knew a situation once where this person did this, and now I'm dragging stuff into this case that has nothing to do with this case. Have I just increased the chances that I'm going to make a mistake? Okay, absolutely. If all you have is the story of two parties, that's what you work with. And then you're trying to make credibility assertions, you're doing the best you can to figure out what story holds true. We're going to look at how you weigh that. But if you only work with the facts that are in evidence, and you go through, lay out a chronology, this work is actually not that hard. It's a lot of effort, but it's not hard. And mentally, you'll feel a lot better walking away going, I can sleep with this decision tonight. Okay? And if nothing else, something to remember. And I'll actually start with the question. In the United States of America, in public institutions, students have a right to an appeal. How many say that's true? The student conduct process. How many say that's false? Usually no court in the land has ever said an appeal is required. Believe it or not. But there are probably only a handful, maybe 5 institutions, guessing at that number, that don't use appeals. And what are those institutions in their nature? Small, private, religious. I guarantee you, if you look for non-appellate processes, that's what you're going to find. In every other institution in the U.S., you will find appellate processes. Why? Because A, we recognize people can make mistakes, and B, because we recognize that the potential for bias exists. And so, even if you go to bed not entirely certain of that decision, understand people have process. And they can follow that process. Okay? What does it mean to weigh information? Any questions on that section so far? We're going to go 2 more minutes and then we'll take a quick break. But what does it mean to weigh information? We're going to go through 1 or 2 of these. When we weigh information, we're seeking to assess the impact of what's presented to us. And so the factors that we're going to look at include persuasiveness, relevance, reliability, and bias. This is what we're looking for. Persuasiveness, if we're going to be persuaded by something, it should be believable. it should be generally consistent. Generally consistent, and that it should essentially hold up. It should be, if not, I don't expect that if somebody tells a story 3 or 4 times, and I don't imagine you expect this in police work, that they're gonna do the same sequence of events, they're gonna say it in the same words, and then it's all gonna match point for point. But if we took a snapshot and pulled all of their stuff together and saw that it was complementary information, that it built on top of itself and wasn't inherently contradictory, we would see that as pretty credible information, right? In law enforcement work. And that would hold true for us. That what we are looking for is generally reliable, consistent information. What toys with consistency in Title IX cases? We're going to spend a lot of time talking about it in the next session when we get back together. But what really plays with this is something called trauma. Because here's the thing, and I understand from the session this morning, y'all are using the read technique for questioning? Yes. All right, which I've had some experience with in New York. Great interviewing technique if you're a police officer, and really cues you on how to read deception. And not to just detect deception and then assume somebody's being deceptive, but use what you perceive as that deception to continue asking questions, right? And so I might kind of norm, to steal some of the language right there, right? You get me talking, and we're just having a conversation before we get to the tough stuff. And what are you looking for there? Patterns. How do I normally communicate, right? And then you start asking me about the hard stuff. Am I sticking to those patterns? Am I varying from those patterns? If I'm varying, is that attributable just to being a little bit nervous, or do I look like I'm being deceptive? What if my eyes are going up and to the left, right? And so, I mean, you can take this out a long, long way, but ultimately, we are looking for information that is consistent. Now, the problem that the police run into is the tells that someone who wants to be dishonest would give are extraordinarily similar to the tells that a trauma victim gives. And I could not understand for the life of me, I've been doing this this is my 26th year, and I was a hearing officer for many, many, many of those years. And I had one female detective, police detective, who handled a lot of Title IX cases. And it always bothered me that every time she brought a case in, either explicitly or implicitly, she did not believe that victim. And I couldn't understand, was there something going on with her in her past that was kind of really short-circuiting her ability to examine this? What was going on here? I couldn't understand it, and I was really, in some ways it was really affecting my relationship with her, because she wasn't coming across as credible because it seemed like she had a real bias. Then it occurred to me one day when we were having a conversation about trauma, it was her training. It was her training that was throwing her off, because the tells, the visual tells and the verbal tells that she would get from people who were reporting these situations was identical to people who would otherwise be deceptive. And so this is a huge area where we now understand that if you're going to investigate and you're going to interview people that have been subjected to a traumatic experience, you need somebody who understands how to read these signs. Right? And so that has really, it's complicated the work, but now that we're acknowledging of it, now that we recognize that it's a problem, there's a great deal of resource that's available out there for us. And so now we know how to address that. But that's something we have to watch. But in general, when we're looking at whether or not information is persuasive, it needs to sustain itself upon being challenged. It can establish a dependable narrative for us that outweighs any inherent deficits. So that's what we're looking for. An example would be well, I shouldn't say an example. To me, this is not about how many witnesses. It's about the quality of each witness. And the example I use, and then we'll break. The example that I always use in this case is, I had 16 people saying one thing in the case, and I had one person saying another. I had a football player, quick story, this one guy who's a fraternity member of a local fraternity at this school, so not even a national, walks into another apartment that this football player rents. The football player wasn't known before his guests were, and he walks into the apartment without invitation, had to open a door to do so, goes into the kitchen, goes to the refrigerator, takes out a beer, and starts to walk out. And the guys are like, "Yoo-hoo, people here, who are you, what are you doing?" He says, "Yeah, I'm just grabbing a beer." "Do you know this guy?" "No." "Put the beer back." "No." "Dude, put the beer back." "Well, you don't want to tell me that." "Put the beer back and get out of here." So he puts the beer back and goes. He's like, "You haven't heard the end of this." So that night, football player comes home. They're talking about it. Because that's weird. They'll go to bed, and about 1:30 in the morning, the door comes off the hinges, and 16 guys come through the door. Not making this up. Football player, 4 of his guests who were camped out for the game, they're all dragged out of their sleeping quarters and beaten by these 16 guys. So the quarterback is able to identify 2 of the guys he knows by face. 2 of the guys he's able to pick out of the photo lineup. The other 12, we have no idea who they are. So I've got these 4 guys now that are charged. I've got the football player. The football player comes into the room with his coach. They're sitting over on one side of the table. I got 4 guys and their attorney at the other end of the table. And what I've got, ironically, is 12 witnesses sitting up in another room. 4 plus 12, okay. And so we go through, and I'm asking these guys to tell their story, and I start with respondent number 1. So, where were you that night? Well, we were down at the house. What time were you down at the house? Oh, 7 at night to 3 in the morning. That's 8 hours by my measurement. Everybody here, same thing? 8 hours? It's a long time. So what were you doing for 8 hours? Well, Mr. Olshack, we'd like to tell you that, but that was related to our new member initiation process, and so therefore that's protected information. No. You're using it as an alibi. You will answer my question, or I'm not going to believe you. Oh, well, okay, we were playing games. What do you mean? We were playing word games. Okay, well, any Greeks here? Okay, what do we mean by word games? Stand online. Questions about history of the fraternity or sorority, right? Got to answer those questions about the founders and the principles and all that. And of course, and I said, and if the guys get it wrong, then they got to voluntarily do push-ups and sit-ups. Well, yeah, voluntarily. Thanks. Okay. Still a hazing violation. That's okay. They're not charged for hazing. So what else did you do? What do you mean? Police? Ding, 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 ding. Right? Warning lights going up. Well, what do you mean, what do I mean? Did you do anything else that night? Well, we played games. Just that game? Well, yeah, we played that game. Did you do anything else? Well, I'm not sure what you mean, but we took some breaks. Okay, so how long were the breaks? So we took 2 breaks. They were about 15 minutes each. All right, so let me get this right. For 8 hours, you played the same word game over and over and over again, and you took 2 15-minute breaks. Now, you think maybe they're getting a sense I don't believe any of this? Okay, they should be by now. Now, I'm being far less snarky in that setting than I am in this one, okay? I know better as a hearing officer, but I'm not hearing the case right now. So, you did this for 8 hours. You didn't do anything else? Well, we played variations on that game. Tell me about the variations. And so basically he goes into this explanation about nothing. I mean, where, okay, it's essentially the same word game, only now they're playing in their rooms and splitting people up. Okay, that's fine. You still did that for 8 hours. And if somebody's being deceptive with you and you just look at them, even in a really non-judgmental way, what's the message?
You don't believe it?
I'm not falling for it. I'm not buying it. So they realize I'm not going to go away. And one of them, number 1, finally blurts out, well, we play Twister, okay? Play Twister. Okay. So let me be clear. You played word games, different word games. Twister. You took 2 breaks, and that took 8 hours. Yeah. Okay. Let's go to number 2. Is that your story? Yeah, that's my story. Number 3. So get all 4 of them to confirm it. Bring in witness number 1. What is the first thing I am not going to ask witness number 1?
How long they played Twister?
Because what I'm looking for here is what? Well, right, I know that if people are going to band together and create a story, they're going to create a story. So what am I looking for? Areas they might not have thought to cover, right? And so, witness number one, what were you doing that night? We were down at the house. From what time? 7 at night till 3 in the morning? What were you doing? Well, Mr. Olshack, I'd like to tell you that, but that's protected information. I mean, literally, it's like it's scripted. I'm like, well, that ain't gonna work. I explained that. He says, okay, we were playing games. What kind of games?
Word games.
It's like you were there. And so I get to hear this description of the word games and the fact that they took breaks and that they did this for 8 hours. You play any other variations on this game? No, I don't know what you mean. Okay. Did you play Monopoly? No, we didn't play Monopoly. Why Monopoly? I'm throwing a breadcrumb, aren't I? And I want to see if he's going to follow it.
Because if they actually played Twister, if you said Monopoly, they'd be like, no, we played Twister.
Right. Or what's going to happen, did you play Monopoly? Oh, yeah. Right? Which is now inconsistent with what they said, but they think they need to go in that direction. So I'm playing a mind game. Trust me, if they're not lying, mind games are fine. Because the story will hold up. It will be persuasive. And so, okay, you didn't play Monopoly. Did you play Life? No, I didn't play Life. We didn't play Life. Did you play Twister? No, we didn't play Twister. Thanks for coming.
He's going, oh crap.
And I let him out of the room. Now, he had no idea.
Right.
Bring in witness number 2. Did the exact same thing. I'm looking at respondent number 1, who writes on a big piece of paper, we're effed, aren't we? And slides it down to the attorney, who just looks over and goes. And after 2 witnesses, I was like, guys, do I need to do this again? No, you don't need to do it anymore. Okay? And so now we're permanently expelling 4 students. And I know I got 12 guilty guys sitting out there, but there's nothing I can do about it. Okay? We could identify the 4, we take care of the 4, and then we move on. Okay? But the fact is they weren't persuasive. Despite 16 of them being willing to come forward, they weren't persuasive. It didn't hold up.
Did they ever say why they did it? I just told what was
That particular...
Like, what was the 16 guys to go?
This was, and actually I'll throw the school under the bus only because who cares? It was SUNY Cortland, and so Cortland is situated up between Binghamton, Syracuse, Rochester. You go up that corridor. And this particular local fraternity really was a bunch of guys from Staten Island who were all living in a house together who were peddling drugs. So they really didn't believe that any rules or laws applied to them. My last night on the job, I actually sat in a squad car with one of the detectives up on a hill behind the house while we watched the police raid a drug raid. Because we had students who were going in to serve as CIs in that case, confidential informants. And so I got to sit there with my last night in New York and watch a drug bust. Which was, I mean, it was kind of this going away present to me. I was like, this is cool. Sitting on a stakeout. I'm doing what I needed to do.
So they regularly do this kind of thing then? I mean, was
actually in another case, same group, took one of their pledges, he had been telling his, and I won't go too far with this, he had been telling his girlfriend about the pledging process because it was particularly brutal. And he happened to be talking to his girlfriend on the phone. Back in those days, phones were attached to these things called walls. And so, he's sitting there on the phone. He happened to have his door ajar, and somebody walked past his room and happened to be the girlfriend of the pledge master. So she goes back to her room, she calls the pledge master. He goes out to the cash machine to the ATM that night to get cash, gets abducted from the cash machine, thrown into a trunk, taken to the house and beaten for several hours. I mean, that was the way it worked there, so I don't mind throwing the institution under. It was 3 of my most active years in my life. My caseload there was the same as when I moved to a school of 21,000, and they were a school of 7,000. So it was a tough environment. But persuasiveness here, they've got to build a compelling story and it's got to hold up. Okay? let's take a break here, about 5 minutes, just get everybody out of the room, it's getting a little warm, and get some beverages, restroom across the hall.
If you haven't signed both sign-in forms, please do so.
How you doing?
Good, sir. Good, sir. I had a conversation about it.
Looks like it's really
2 weeks ago.
Oh.
Volleyball.
Oh, yeah, Justin Manus. Yeah. Oh, good, man. I was really happy for him and Sulphur Springs. I think that was a really good hire. He just got just a terrible situation in Paris. Yeah, he was